Hi, I'm Cheri Harris. I am a legal consultant and the director of the certification program here at the Indiana State Library. I also get to call on for this particular topic a little bit of experience I have from 10 years of teaching full force self-defense. And one of the issues we covered in my class was verbal boundary setting, which is something we're going to talk about a little bit today. So it's kind of an exciting opportunity for me to marry two different parts of my life experience. I want to thank Sylvia Watson and Cheri Cleveland, who will be monitoring your questions as they come in. You will need to put them in the chat, and I will not be able to see the chat most of the time. So one of them will direct questions to me at appropriate intervals. As far as any sound issues you might have, we are recording this meeting and you can watch it offline after the meeting ends. So with that, I think we might be ready to get started. I do want to, well, like any good attorney, I'm going to start with a disclosure. And you can read that. Basically, there's no attorney-client relationship here. So this isn't considered legal advice. It's really just a source of information about the topic. I looked at federal law, and my remarks are, I did not look at any other state laws. So my remarks are specific to Indiana libraries. I haven't looked at other industries. And my remarks are current only as of today. Everything could change very soon for all we know. I do want to say that I found this topic interesting and I learned a lot. And this is kind of a brief outline of how I'm planning to approach this, talk a little bit about state and federal law. I will work in a little bit of information about a couple of cases. And then I want to be sure there's time for maybe the last 20 or 30 minutes, ideally, to look at a couple of scenarios and talk about how the process works to just parse through the language and figure out whether or not a situation is actionable, and talk a little bit about what to do if the situation is not actionable. And my goal for today is really just to begin a discussion about what constitutes sexual harassment in a library context, and to introduce the fact that an employee has a right to a safe workplace. Certainly, this will not be the final word on any of these things. There's a lot of information out there on this, and in a way, I can only touch on what I think the highlights are. So sexual harassment is a form of sex discrimination and violates Title VII of the Civil Rights Act of 1964. So when we talk about Title VII, that's what we're referring to. That's a federal law. Sexual harassment is prohibited under state and federal law, and it may also be prohibited under a local city or county ordinance. Some local areas have a whole separate system for resolving local issues under local ordinances. Engaging in workplace harassment is prohibited and can subject an employee to disciplinary action up to and including dismissal. Oh, somehow. Okay. Yes, I've already gotten my pages a little turned around. Okay. The stated purpose of the Civil Rights Act of 1964 is to prevent discrimination in federally assisted programs. And of course, you probably are quick to conclude that pretty much all libraries are federally assisted programs, because any funding you get from the state is largely passed through from the federal government, and they sweep up just about everyone in our industry with that qualification. Although that doesn't necessarily bring you under the Federal Civil Rights Act, it does mean that the purpose is to prevent discrimination. So this list of who the Civil Rights Act prohibits employment discrimination against, this is basically a list of protected classes, protected groups. And while the reason I've highlighted sex in this list is because we're only looking at one type of discrimination today, and that is sexual harassment. I will talk briefly about intersectionality in just a little bit. The agency that enforces the Civil Rights Act is the Equal Employment Opportunity Commission. And the Equal Employment Opportunity Commission covers employers who have 15 or more employees. That sounds pretty simple, but it can actually be tricky to figure out whether this applies to you, especially if you're in a mid-sized library, because there's a formula for figuring out whether or not you have 15 or more employees based on, they look at whether you have 15 or more employees for each working day in each of 20 or more calendar weeks in the current or preceding calendar year. So that could take someone a little while to figure out whether or not you fall into that category. Again, I've highlighted sex. And I did come across language pointing out that because of sex or on the basis of sex also include, but are not limited to, the basis of pregnancy, childbirth, or related medical conditions. So discrimination against a person for being pregnant or having related medical conditions, or, you know, yeah. Those things are also prohibited under the guise of protection from discrimination based on sex. So the first part is with respect to hiring, compensation terms, conditions, or privileges of employment. The second category is if it's unlawful for an employer to deprive an individual of employment opportunities or otherwise adversely affect his status as an employee. Isn't that funny how the sex discrimination statute itself resorts to a gender, traditional gender form? But anyway, on the basis of sex. And then there's a third category too, which is that it's also unlawful employment practice for an employer to discriminate against an employee because the person made a charge, testified, or participated in an investigation, proceeding, or hearing. So that is, you know, a prohibition against retaliating a person for exercising their civil rights under this statute. Interestingly, the EEOC, the federal agency charged with enforcing civil rights, defines sex to include gender identity, sexual orientation, and also, as I mentioned before, pregnancy. So it just how sexual harassment is unlawful is that it falls under sexual discrimination because it can interfere with the person's ability to have access to the workplace. I mentioned that I was going to talk about intersectionality a little bit. I want to acknowledge that limiting our topic to sexual harassment creates sort of an artificial distinction because a Black employee may not know if she is targeted because of her race or her sex for harassment. How do you define the harassment of an employee from another country? as being based on their national origin or their sex. Just often the analysis is really more complicated than is represented in this program today. But the reason I'm only discussing one type of harassment today is so that I can go into depth. We've had just a lot of requests for education on this specific topic. It doesn't mean the other parts, the other classes, groups of people that are covered by the law against discrimination are any less worthy of attention. It's just that what the request I've heard over and over for years now has been, would you please present something on this? And then I also just want to acknowledge that while we're talking about sex discrimination, that people who are part of an intersectional who identify with more than one group are probably at a higher incidence of sexual harassment. So people who are Black, Indigenous, or people of color have a higher incidence of sexual harassment, according to some studies, than their white colleagues do. And people who identify as LGBTQ plus experience higher incidence of sexual harassment than their straight or cisgender colleagues do. I want to mention here, well, as far as materials, I will be, after this program, I will be sending out a copy of the slides and also a separate document that has resources on it. And there will be a list of links to various resources that I'm mentioning today. And there will also be a short description of a couple of cases that I will mention today. And then there will be some additional scenarios mentioned that I won't have the chance to get to today. So the first of the resources that I want to mention is that last week, I think it was last week, on June 15th of this year, the EEOC issued a new guidance document that I have summarized and described a little bit in the resource document that I'm going to be sharing. But the new guidance is both talks about how the Bostick case affects EEOC, how the Bostick case affects sex discrimination law in the federal realm. And then it also goes through a number of examples of what have been ongoing legal positions of the EEOC that people may not be aware of, such as their position that gender identity is included in discrimination by sex, and as is sexual orientation. So a number of issues are covered in that new guidance. Maybe exciting for some of you that may not have seen this particular guidance yet. Okay, now we're going to talk about some of the terms or definitions that come into play when we talk about this topic. So protected classes refers to the list of people who are covered by the law that the previous slide referred to: race, color, religion, sex, including gender identity, sexual orientation and pregnancy, national origin, age, disability, genetic information. So of those protected classes, we are just looking at sex today. The rest of these get a little more detailed. Workplace harassment can take many forms. I've listed a number of them here. This is a definition from the EEOC about general workplace harassment that's not specific to sexual harassment, yet it is still relevant. And it does start to define that idea that there is either a frequency or a severity threshold that needs to be met in order to find that harassment has created a hostile or offensive workplace. So that is significant. And also, while workplace harassment sounds like it takes place in the workplace, it doesn't necessarily, that is not always the case, because work-related events, including social events that might be work-related, are also part of the things that affect the workplace environment and can be considered workplace harassment. More specific look at sexual harassment. This is also an EEOC definition, and there is a link in the resource document to a fact sheet on sexual harassment. This is the federal definition, and it varies a little bit from the state definition, in that the federal definition focuses on unwelcome sexual advances, requests for sexual favors, other verbal or physical conduct of a sexual nature, and then sets up a handful of reasons that these things can become sexual harassment. And that is if they affect an individual's employment, unreasonably interfere with the individual's work performance, or create an intimidating, hostile, and offensive work environment. So now it makes sense to mention that there is a predominance among library workers in complaints about sexual harassment coming from patrons, third parties, but in their workplace. And that is still part of sexual harassment, covered by sexual harassment. However, if you look at those 3 bullet points, the first 2 there, the first one, affects an individual's employment, is probably only going to be if the harassment comes from a coworker or a supervisor. The patron probably doesn't have that much opportunity to affect an individual's employment most of the time. But the last 2, unreasonably interferes with an individual's work performance or creates a hostile work environment. Those are things that could be perpetrated by either coworkers, supervisors, or patrons. So that breaks down with, some of the qualifications for behavior to arise to the level of illegal sexual harassment will apply to patrons, and some of them will be more likely to apply to employers. I think it might be easier to see that when I move to the next slide, so you can see the slight difference. But I do want to point out that intent is not an element here, but the fact that the advances are unwelcome is. So the perpetrator doesn't have to intend to harass a person in order to be found guilty of harassment, but the person who's being harassed does need to consider it unwelcome. And because of that, I'm going to recommend that the person being harassed makes it clear that it is unwelcome attention. So this is the state, this definition comes from state policy, and pretty clear definition of sexual harassment that is in the Indiana State Policy on Workplace Harassment, which is available at the Indiana State Personnel Department's website on harassment. And there's a link in the resources. Again, intent is not an element, but the fact that the attention is unwelcome is. If you look at the elements of these definitions, we're going to parse them out a little bit when trying to decide if a particular situation constitutes unlawful sexual harassment. So in the state definition, there are 2 bullet points. The first 2 bullet points really only probably apply to a supervisor, that it's a condition of employment, or that the their response to the unwelcome advances will be used in determining employment decisions that will affect the individual. The third only, so here two apply pretty much only to employers or coworkers or supervisors, mainly supervisors who would have that kind of control over your employment. And the third one, though, of unreasonably interfering with your work or creating a hostile or offensive working environment is going to apply not just to members of the same organization staff, but also to third parties, including patrons. So really, the language is pretty much very similar, except that it breaks out. The third bullet point in the states puts together two of the bullet points from the federal language and vice versa, I believe. So couple more concepts related to harassment. The idea of quid pro quo, which I'm not really going to probably use that much, but is often used in the literature on this topic, means this for that there is an exchange. It's really, if I go back to the previous slide, this section on submission or rejection of such conduct by an individual is the basis for employment decisions. That's basically putting in the statute that there's a quid pro quo makes it sexual harassment. So the idea of the exchange, just an example, whether it's spoken or unspoken, the employer is basically, or supervisor is basically saying, you have sex with me and I'll make sure you get that raise, promotion, plum assignment, or if you resist, you will get the bad schedule, no overtime, crummy assignments. I think of it as, you'll be sent to Siberia, which isn't literally true in the case of the library, but you may have parts of the library that seem like Siberia. I don't know. It's a figurative example. Okay, so for a hostile workplace environment, the best examples I found were in very recent cases that are described on the resource sheet, where there is overwhelming evidence of wrongdoing over a period of years that the management knew about or caused and ignored despite complaints. So it is not likely that a civil rights agency or a court will find that a hostile workplace environment has been created by an isolated incident. And that ends up being relevant because a lot of the examples that were submitted to me were probably isolated incidents. So they probably don't amount to creation of a hostile workplace. It is important to remember that the target of sexual harassment can be a person of any sex or gender, and the harasser could be a coworker, a supervisor, could be a non-employee, such as a client or a customer, in the case of a library, a patron, or an agent of the employer. And also that harassment can exist between members of the same sex or members of different sexes. So basically, there's no exception for things that harassment can happen in any configuration, and any person might be a harasser, regardless of whether they share your sex or gender or share your sexual orientation or not. That a man can be harassed by a man and a man can be harassed by a woman, even though by far the majority of cases that I've seen and the majority of examples that I've gotten involve a man harassing a woman. The EEOC also says that the harasser can be the target supervisor or a supervisor in a different area. And whether it comes from another employee or a non-employee, harassment is prohibited and should be reported. That's when I talk about the cases or the examples, it may seem like I'm sticking to really traditional situations, but that's because that's what people are comfortable submitting to me for the most part, I would guess, not at all because it doesn't happen. Okay, so if you experience an incident, I recommend that you be clear that the attention is unwelcome and unwanted, and that you keep track of information about what is going on, that you keep, especially if it's repeated, that you keep a list of the dates, times, who witnessed, if any coworkers might have witnessed what happened, that you put the details in writing while they're fresh in your mind, and you can actually address who said what to whom, and that you keep track of this information, even if you aren't sure that you want to file a complaint, because after the first or second time somebody says something offensive to you, you might think, your job is just to deal with it. But if it continues to get worse and you decide this is not tolerable, you want to have a record of when it started and how it started and how much it was repeated, because that will help determine whether or not the authorities find that a hostile workplace has been created. So Indiana civil rights law appears in Indiana Code section 22, Title 22, Article 9, and that is where the Indiana Civil Rights Commission, I believe I just have the wrong word there, was created. Actually, originally it was called the Civil Rights Committee, I think, and then later it was changed to Civil Rights Commission, maybe. I'm recalling that. Okay. The focus of the Indiana civil rights law is a little bit different than the federal civil rights law in that it talks about the importance of equal opportunity for education, employment, access to public conveniences, accommodations, and housing. So it's not that the federal law doesn't maybe cover these other things too, but the federal law seems to devote more resources to a fuller definition of what sex discrimination is. And the goal is to eliminate segregation or separation based on these protective classes. But interestingly, and I don't know that the federal law doesn't have this at all, but the state civil rights law in its list of purposes also includes protecting employers from unfounded charges of discrimination. And I think that may give you just a little bit of a hint about the flavor of civil rights in Indiana, that they are offered a little more hesitantly maybe than in federal law. And under the Indiana law, the employer is the state or any political subdivision thereof, and any person employing 6 or more persons, So above 50, if you have a larger organization, you're probably gonna wanna look closer at the civil rights, the EEOC's structure, law, guidance documents, and statute and procedure. And if you have a smaller organization, you're probably going to want to look at the Indiana civil rights law and the ICRC. Interestingly enough, in the definition of sex in the Indiana statute, the statute lists what is not a discriminatory practice, which is just kind of taking a reverse approach from the federal statute, which lists what is considered a discriminatory practice. So that again is a suggestion about the shape of Indiana's law. Like the federal law, retribution is not allowed. The statute does state that you can only file one complaint, and the statute authorizes a city or town or county to create its own ordinances and local commissions. But then it also specifies that any damages paid for discriminatory employment practices under a local ordinance or ordered by the local commission are limited to lost wages, salaries, commissions, and fringe benefits. So the main point here is that Indiana's statute excludes private companies with fewer than 6 employees. There's just a carve out for them that doesn't exist in most other states, although it's not completely unique to Indiana. There is something that is, as far as I know, pretty much completely unique to Indiana, and that is that, and this is under state statute, not referring just to local rights organizations, but to pursue a legal claim in civil court, the statute requires both the respondent and the complainant, meaning both the harasser and the harassee, both the employer and the person who has been is complaining of being harassed, must agree in writing to have the claims decided in a court of law. There are some articles out there where civil rights attorneys and scholars just marvel at how this wording limits remedies under Indiana law, that you basically have to get permission from the employer to sue them for violation of your civil rights, which also is another way of saying the state statute wants you to go through the commission, the ICRC, rather than go to court with this case. But if you are able to persuade your employer to sign this authorization for you to take the case to court, the statute says that allows you to file a civil action that must be tried without benefit of a jury. So, okay, that's the pretty unique aspect to Indiana law. Now we're going to touch on a couple of other related concepts, and I'm going to go through these pretty quickly, I think, because I still want to get to scenarios to discuss before we are done. And it looks like we're a little more than halfway through our time. So sexual harassment can affect bystanders, and a bystander can be the one to report an incident or file a complaint. So here's some thoughts about what bystanders can do and possible bystander interventions. And that's, I'm just going to mention that. Risky behavior is something that touches on the edges of what's legal or not. It is behavior, it may happen over social media rather than in person or in the workplace, but it is harassment that may not involve spoken words or physical touch. So it could be telling of inappropriate jokes, or it could be inappropriate postings. My main point for bringing this up, well, 2 points. One is that the best approach an employer can take, that management can take, is to make it clear that risky behavior is not allowed, because where risky behavior is allowed, it often will accelerate to become illegal behavior. So I came across this meme just a couple days ago, and I thought, oh, this is another way of saying this. I have taught judges and court staff ethics on occasion before, and I like to say to them, if you're not sure whether it's okay to do something or not, consider how would you feel if your mother knew about it, that you had done the thing that you're considering whether or not it's okay to do. Or better yet, how about if it was on the front page of the New York Times? If you have any hint that you might be embarrassed or ashamed about that, just don't do it. So the point here is that thinking it's funny doesn't excuse you from posting, tweeting, emailing, texting, something that will make someone else feel uncomfortable, which is a lot of things. And a lot of times we don't know what might make another person feel uncomfortable. But if thinking of how you would feel about your mother knowing doesn't do it for you, if thinking about the, being on the front page of the New York Times doesn't do it for you, then this is a suggestion that you imagine your lawyer, this accusation of you doing such a thing is read in court one day. And it will be if it turns out to be illegal and somebody pursues it. Okay. So the duty of managers and supervisors are to create and model a culture of civility within the workplace, to make sure that employees know what the policies are that prevent workplace harassment and what procedures to follow if they are subject to harassment or witness harassment, and the range of reporting options they have. And I was looking at Indiana's workplace harassment prevention policy, and there are 5 different places a person could go to report that they have been harassed. So it's important to have options there about who you can talk to. The fact that you need to comply with Title IX exposes certain training needs for your organization, that it's important to train managers and supervisors how to recognize and respond to sexual harassment complaints. And for example, depending on the personality of the people who are your managers and supervisors, you may need to remind them that these are issues that can be very difficult to talk about, and that it's likely that a person may require privacy as well as tissues in order to have that conversation with someone that they are trying to report a complaint to. Okay. Also, it's important in doing those trainings to remind managers and supervisors that retaliation against an employee for filing a complaint is also unlawful. These are some recommendations from an EEOC task force on the study of harassment in the workplace. And I'm not going to read them, but this is from a report that came out in 2017. So it's not exactly new, but it's pretty solid examples of effective approaches, and it does overlap with other guidance that I came across when I was putting this together. In the resource handout, there are links to Indiana's workplace harassment prevention policy, which is several pages long, but worth a look. It's very thorough. There's also a link to Indiana State Library's patron behavior policy, and other policies can be found on the State Library website too. Here's a list of policy provisions to consider. If you should already have a policy, but if you don't, these are things that would be worthy considering. This isn't everything. This section is pretty brief, and there's certainly more that could be said about it, but the primary concern I've heard is what can I do in response to situations that make me uncomfortable? And for most of us who are not policymakers, the biggest option is how to respond to those situations. So I will move on to where I ask the question again, is this sexual harassment? How would you do the analysis? And let's see. You are entitled to a workplace free of sexual harassment. That doesn't guarantee you a workplace free of jerks. You will have unpleasant interactions because you are a public-facing, service-oriented employee, and you deal with the public. And unpleasant encounters do not necessarily constitute harassment or illegal harassment, prohibited harassment. So my boss, who may be on this call, is a perfectly delightful person. I noticed originally I had written down, what if my boss is a jerk? But my boss is not a jerk. So I'm going to put this differently. What if your boss is a jerk? That may be unpleasant for you, but that doesn't mean it's actionable. You have to figure out how to coexist with coworkers and other people in your environment, but that doesn't mean that you have to like each other or socialize after work. So there are limits on, figuring out where exactly that divide comes, finding the line between annoying behavior and actionable behavior. So some of the things that you'll want to look at and be aware of. Cases are very fact specific. Context matters, tone of voice, body language, nature of eye contact can make a difference to the analysis. You need to focus on the behavior and identify specifically how it violates the law or how it violates a policy. And be aware that finding a hostile workplace usually involves a sustained pattern of really bad behavior, as opposed to kind of moderately bad behavior. And also, I'll just acknowledge that there is a tension between the constitutional interest in the public's access to libraries, which I have discussed in other presentations, versus protecting the safety of frontline library staff. And that, to some extent, came out in one of the earlier opinions on libraries. It was kind of a unique opinion. It was before the Child Protection Act that allowed libraries to put limits on access to pornographic materials using public library computers. So the staff of that library sued for the creation of a hostile workplace that made it intolerable for them to work in, and that they were regularly reduced to offensive behavior, exposed to offensive behavior by a core group of men they described as pornography addicts whose behavior, once they were allowed to come to the library and surf websites that would not normally be considered family friendly, for long periods of time, that they became increasingly unruly and subjected staff to worse and worse behavior. And in that case, the library settled with the librarians, but not long after that, the court upheld the statute that libraries now rely on to limit that, but actually forced to limit that. Okay, so that was more than I really intended to say about that at this moment. Okay, is it actionable? So I've broken down this into the elements of the statute and kind of configured it as questions to ask when you go through a specific situation. Was it an unwanted sexual advance, request for sexual favors, verbal or physical conduct of a sexual nature? Which may be summarized as, was it unwanted and sexual? And if the answer to that is yes, then you move on to step 2. That alone doesn't make it unlawful sexual harassment. What makes it unlawful sexual harassment is if, in addition to meeting that standard, one of the following is also true. that it's a term or condition of the job, that the employee's response to it can be used as the basis for affecting employment decisions. Does it excuse me, unreasonably interfere with my work performance? Was it so frequent or severe that it creates an intimidating, hostile, or offensive work environment? So my suggestion here, as we talk about specific scenarios, is that it's important to take kind of a cold, hard look at the facts and be analytical rather than emotional. This is kind of a skill that many attorneys have, but it's also important to resolving some of these situations. Does it meet the elements of the statute? And if so, was it a pattern of behavior or an isolated incident? Are going to resolve many of the scenarios that I was provided with. And if it's not actionable, this is why I brought up that I have included a little bit about patron behavior policies in the resource document. If it's not actionable, then if it's perpetrated by a coworker or supervisor, you're going to want to look at the library's sexual harassment policy as it applies to staff. And there may also be something in the library sexual harassment policy that addresses third-party harassment. There probably should be, but if there's not, there is another way to deal with that. That is, if the perpetrator is a patron, I think it makes really good sense to look at whether or not the behavior violates the library's code of conduct or any other written policy of the library. And then if so, you kind of have a blueprint right there in most written policies of how to proceed, that most of them involve warning the person and maybe telling them what the next step would be under the policy if the behavior continues. So that's where I would go on an awful lot of the scenarios that were submitted to me. And I'm only going to try and discuss a few of them, but before we get to scenarios, I want to talk a little bit about setting a boundary. The first thing I want to say about that is that speak with the knowledge that you have every right to set a clear boundary. So feel confident that this is an important and valuable thing to do. I think that many of us who are drawn to positions as service providers, and certainly most women in our culture are raised to believe that we want everyone to like us, and we're supposed to be nice all the time so that people will like us. And this is a time when you're not trying to make friends here, you're trying to make a clear boundary. And the best way to be persuasive about that boundary is to sound serious and neutral, to bring your voice down so that it's deeper, and end your sentences with a period, not a question mark. Practicing what to say is good, and I have helpful phrases coming up next. And role play is also good. But I did have one person say, I always freeze. I just am incapable of responding appropriately when I'm upset or embarrassed by the way someone has talked to me or gestured at me or done something in front of me. And I just freeze and I can't think of what to do. So here's my, $2,000 suggestion. Write the response that you would like to have and are able to come up with in a moment when it's not happening onto a note card or an index card, and carry that with you in your pocket or post it on your bathroom mirror at home until you have really learned some of these phrases and they're pretty ingrained in your mind. And if you have to pull your card out of your pocket to remind yourself what to say, you can do that. But I bet you probably won't even have to, because if you carry that phrase around in your pocket for a couple of days or a couple of weeks, and then you run into the person who you particularly are not happy to be helping, you'll probably remember it at that point. And I would just say, don't dismiss this, because it is a remedy that can be very effective. A lot of times, people who are harassers are looking for a reaction. In my experience, based on people that I know in situations I've been in, I think often they're looking to shock someone. People who say offensive things regularly want to shock people, and that's why they say them. So don't give them the reaction that they're looking for. Try to be very rational and calm about it, and serious. So with that description of how to say these things, then here's a list of statements. These are the kinds of things that I taught in self-defense, except that maybe not quite so specific to libraries. And I will say one of the things that we always recommended was labeling the behavior. It's okay to make this impersonal. It's okay if you're angry, you can channel that anger into clear communication. But I think if you can avoid being upset or letting the person know that you're a little discombobulated by what they did, you have more of an advantage. So this link is also on that resource document, and the article talks about some of the things that I've already talked about in terms of how to deliver some of these statements. And one more thought, what you may want to write on that index card is something along the lines of, if you say it and it doesn't happen and you have to say it again and maybe even a third time. So the first time, just a statement, that's offensive, don't do that in front of me or to me or call me that. And then the next time it may be more along the lines of, I've already admonished you that that is inappropriate and you need to stop that behavior now, or I will report it, or here's the section of our policy that you have that does not allow you to continue that behavior. So if you continue, you'll be asked to leave the library. That kind of a script where you have to say it more than once is kind of a realistic approach, because people don't always listen the first time you say something. Okay, so to the scenarios. Are these unpleasant, uncomfortable encounters, or are they actionable? A male staff member asks a female staff member while on vacation to send him pictures of herself in a bathing suit or not. Okay, well, there's no question that that is sexual in nature, I think. What I don't know is whether this is repeated behavior or pretty much isolated behavior. Based on the description of this situation, it sounds like it might be pretty, relatively isolated. And I'll give you an example of a very similar comment that was discussed in a settlement by Walmart Stores East. They had to pay $410,000 and provide relief to settle a sexual harassment lawsuit brought by the EEOC. For 4 years, a male employee of Walmart regularly made unwelcome sexual comments, vulgar comments about people's bodies of female employees, comments on female coworkers' breasts and buttocks, told a female coworker, "I can't wait to see you in these," referring to thong underwear, and touched female coworkers without their consent, including pressing his crotch against a coworker's buttocks. And then there's a list of additional advances this person made that even though people had said were not interested in having sex with him, he continued to ask them to. So where the management knew about this conduct for years and didn't do anything about it and had received written complaints, that was considered a hostile work environment. So basically this fact is in other cases, but the order of magnitude of the cases where they find a hostile work environment is much greater than just this one thing happening. So that's just an example. And I would say the same thing about the next one. A male staff person tells a female staff person to take off her mask because he likes to see her face. Similarly, I mean, does that happen every day? Is that combined with a bunch of facts that are pretty pernicious and amount to more? Or is that pretty much an isolated incident, is my thought on that one. Without additional facts, I would conclude that either of these are mostly isolated incidents and probably do not amount to workplace harassment. Okay, the first scenario on this slide is something that actually happened to me many years ago. Coworker said that she'll do anything for $10 about me, but then he became more explicit about what that anything might include. And I was working at a library at the time. The library director and other coworkers laughed and joked about it for the next 5 or 10 minutes. But that was truly an isolated incident. And so even though it was inappropriate workplace behavior and maybe certainly risky workplace behavior, it was kind of telling a joke that might not be funny to everyone who hears it. It's probably does not amount to workplace harassment. Another one that I overheard, was not said to me, a male coworker says to a male employee, who'd you sleep with to get this job, except used cruder language. So does it make any difference here that the target of harassment is male? Does it make any difference here that the harasser and the harassee are of the same sex? It does not make any difference. It still could be considered sexual harassment. But the same analysis that without a lot of additional behavior involved in the situation, it's probably not going to amount to workplace harassment. It may amount to something that you can point to a policy against in your library's written policies, and if so, I would say follow the step-by-step instructions of how to implement that policy. This was interesting. I hope the person who shares this doesn't mind that I couldn't really figure out a way to disguise this one, because the examples are so colorful and involve people that we all know, people have very strong feelings about. So here a patron once referred to wanting to cut off Hillary Clinton's head. Probably not. I mean, is that sexual harassment? There's an implication beneath that, you know, Hillary is a feminist and represents hostility towards all women. That's kind of a long road to travel. And if it happened one time, I would consider that to be an inappropriate remark as opposed to a hostile work situation. But if the same person also refers to women he works with as using unsavory sexual terms, then that inches it up closer to a hostile workplace. Certainly, one of the other cases I looked at talked about a person's manager referring to subordinates as whores. And that was in part of a much larger description of activities, was considered part of creating a hostile workplace. This was a restaurant situation. This case was actually, I believe, handed down yesterday. It was posted on the EEOC's website yesterday. The restaurant's co-owner and general manager subjected a female server to sexual harassment by making humiliating comments about servers' bodies, referring to female employees as whores, and frequently discussing his own sexual experiences with female servers. And then when one of the servers complained about that, he intensified the harassment, threatened her job and her safety, and made work conditions so intolerable she was forced to resign. That was considered creating a sexually hostile, sexually charged, and sexually hostile work environment. But that's a lot more than what I see here, even though these are inappropriate comments, certainly. And then finally, the patron did a built-in impression while talking about sexual acts and using inappropriate hand gestures. Gestures can be considered harassment, workplace harassment, or sexual harassment. Inappropriate hand gestures, that would be sexual. I would take that to be sexual in nature. It wasn't maybe in advance exactly as trying to make someone uncomfortable, and these three things together don't amount to the kinds of utterly overwhelming descriptions that I've seen in cases where the court or the EEOC has found workplace hostility. It has to be pretty significant to find that. And so, I understand why this is upsetting, and I think it's worth figuring out appropriate phrases for these kinds of situations and following through. And this one comes closer to creating a sexual, a hostile work environment. So that's as far as I got with these. I hope that's helpful. It's very strange for me to be doing this without any feedback from you. And I know you maybe have been writing some comments that I have not been able to look at. We are pretty much at the end of an hour here. I'm not sure if people want to stay on just a little bit longer and share questions, or if you want me to answer those, just remotely, follow up and answer questions that come up. Sylvia.
Hey, Cheri, we don't have any questions yet. I don't know if we need to give people a few more minutes or if there just really aren't any questions.
Okay.
We can hold on for a few more minutes to see if any trickle in, but there aren't any right now.
Okay, I'm just going to mention that I have a list of other situations that are not quite fully fleshed out scenarios, but just what people want to know. What do I do if this happens? And what do I do if that happens? And while I'm not going to try and answer those questions, certainly not right now, but not in writing either, I do think they could be useful for a training that a library holds if the director and supervisors, managers want to sort of review and model appropriate behavior. Oh, and I want to mention one more thing, which is that it really is possible to learn the skills, the sort of defensive skills, the prevention skills of deflecting this kind of behavior. I mean, obviously, you're not going to change a psychopath, but I just want to share that I have a cousin, actually my husband's cousin is a librarian, and she is one of the most shy and timid people that I know. But I spoke to her about this recently. She's not in Indiana. I spoke to her about this recently. Well, actually, he does have a cousin who's a librarian in Indiana too, but I haven't spoken to her about it. I just asked her at a family event last month, how she handles these situations and if she comes across so much. And she said it happens all the time. And she has become super comfortable just telling people, don't do that. I'm not here to talk about that. I'm happy to help you find a book, but I'm not willing to do X, Y, or Z. I'm not willing to talk about my personal life. That she learned from her director how to respond to people in these situations and has just practiced it enough that it's become comfortable for her. So even for some of us who think we might be timid or shy or not able to speak up for ourselves like that, it is very much a skill that can be learned. And is there something in the question answer that I should?
I don't say anything yet, no.
Okay. Anyway, so I guess I did want to conclude by saying, feel free to contact me later with questions. I'll do my best to answer them.
Hey,
Prevention.
Cheri, I see a question. It says, if it is harassment from a patron, is it best to try to handle it under a library's patron behavior policy instead of a sexual harassment policy?
So often I think it would be, and part of the reason is because the patron behavior policies that I excerpted a little bit in the resource document, which I will send you, even though you don't have it in front of you right now, oftentimes they list things like, a patron is not allowed to interfere with, a librarian doing their work, or is not allowed to, I just want to give you a couple of examples because they really address the situation very easily. I think it's a much easier standard to meet. It doesn't mean that it's not ever sexual harassment, but for example, the Indiana State Library says behavior that interferes with library services, including the ability of library staff to perform their work, is prohibited. And this includes, but is not limited to, obscene or abusive language or acts, threatening or intimidating others. For example, abusive language, threats of violence or harassment, staring at or following others through the building. I think that this covers so many situations that it would be really easy to manage addressing it this way. So that is really my recommendation, is to look closely at the behavioral policies, and if they fit, follow through with them, that whether you may need to make a complaint or you may need to get a supervisor to address the situation. And it will probably be a graduated sort of penalty that won't necessarily start with throwing the person out of the library, but probably involves a warning, and then maybe ejection for a short period of time, and then maybe ejection for a longer period of time. But yes, I do think that many library behavioral policies are very well suited to addressing these kinds of situations.
Oh, Cheri, I see another question. Someone's asking if they don't address the offender and tell them that what they're saying is inappropriate, does it not count? So I guess the question is, if they haven't told the person that they're offended and upset by this, does that then preclude them from acting on it later?
So this is going to be my opinion, because I haven't actually, practiced in this area. So what happens in the real world versus me reading statutes and cases and interpreting where that line is drawn, I don't think it precludes you from taking action if you don't make it clear that their attention is unwelcome. But I think you have a stronger case if you make it clear that the attention is unwelcome. And since context matters and these cases are fact specific, I think you want to do what you can to strengthen your case. Now, one exception to that might be if the person has so much control over you that it feels like you'll be punished more for saying something than not. Then I think, if the person is your library director or your immediate supervisor, you may want to go to one of the other people that are designated as people you can complain to, and discuss with them how to best handle the situation, because it's a lot to deal with if you have someone who actually has that kind of power over you. If it's a patron who doesn't have employment power over you, I think that's a little bit different analysis as to whether it makes sense or not. Also, sometimes people who have some of these inappropriate behaviors, sometimes it may relate to personality disorders or mental illness related issues. So some people are more amenable to having inappropriate behavior pointed out to them than other people. Some people may need to be explained why it's inappropriate too. So I could probably go on, but I think I probably should cut it short here. And thank you so much for joining us. I would love to hear feedback from you. I will send materials out to you, and do contact me if you have other questions or other ways that I can be helpful in this area. That's it.